Hi, this is Kershaw Talley here. I'm one of the partners working on the Camp Lejeune litigation. And the reason I'm doing this video today is to answer a question that many people have asked us when they call about potentially filing a lawsuit in connection with the Camp Lejeune water contamination issues. The question that people always want to ask or want information on is what does it mean to be involved in a lawsuit? How much time and effort is it going to take for me to be involved in one of these, and what am I going to have to do? And it's important to understand the way these cases work because they are different than a normal personal injury lawsuit. And the big difference is the numbers of people that are involved. So under the Camp Lejeune Justice Act, anyone who was a service member and stationed at Camp Lejeune for at least 30 days, doesn't have to be consecutive, between 1952 and 1987 can bring a claim under the Act for any type of injuries that may be related to the water contamination that was present at the camp. What we expect is there are going to be many thousands of people bringing claims against the federal government. When cases are like this, where you have thousands of people all basically suing over the same thing, those cases are handled by the court system in a very unique way. You can't have thousands of individual lawsuits. It's just not practical, and it would take many years for all these lawsuits to go to trial, right? So what judges will typically do is they will get all these cases. They'll all be consolidated in one federal court in front of one federal judge in North Carolina, and that judge will manage these cases. And the first thing he will do is set up a process to do what's called bellwether trials. And a bellwether trial is different than a typical trial, and we call them bellwethers for a reason. And the idea is that if there's a difference of opinion between the federal government and the plaintiffs as to what a case is worth, what the settlement value of that case is, what you do is you try some cases and you get juries to decide what a case is worth. And if you try maybe 4 or 5 cases with somebody, with individuals who have different kinds of injuries, that will give you a benchmark for what the other cases should settle for. So the bellwether trials are very important to the overall litigation. And the question is, how many of these cases are bellwethers? So typically, you might have 5 cases or 10 cases. It really depends on the individual type of case that you're dealing with. But in this case, I could see a situation where you might have 5 to 10 cases that would go to trial involving maybe 5 or 10 different kinds of injuries, diseases or cancers, and the experts would testify and a jury would come back with a verdict. The idea of what is a case worth would be decided by the jury. After you have a couple verdicts, then you should be able to settle the rest of the cases. And these cases really settle in a unique way. What they do typically is they settle with a formula. So there might be a formula that for one type of cancer, a plaintiff would give X amount of dollars. For a different kind of cancer, they might get a different amount. But that's typically how it works. There will be a formula that's used to determine how much each person would get. Now, what's really important to know is at the end of the case, everyone's case is individual. This is not a class action. A class action has one person filing a lawsuit for thousands of other people. Because these cases are so unique and the damages are unique, each person has to file their own individual lawsuit. And what that does for the person is it puts them in control of the process. Because at the end of the day, when the case settles, each individual plaintiff will have to make their own individual decision as to whether they want to settle their case for whatever's being offered under a formula or go to trial with it. So that is how these cases typically resolve. As far as what it means to the individual plaintiff as to what they have to do, it really is unique in the sense that when you're one of many thousands of people, you're not going to have the defendants focusing a ton of attention on you directly because you're one of thousands, right? So the chances that you'll ever have to go to court, show up for a deposition, are very, very small. Typically, what happens in most cases is the plaintiff would have to fill out a questionnaire that describes what their injuries are, what kind of cancer they had, or what type of disease they had when they were stationed at Camp Lejeune. And for most people, in 99% of the time, that's all they have to do. If you're not picked to be one of those early bellwether trials, the process is pretty simple and pretty easy. And we could guide you through that process. So if you've been impacted by the water contamination issues at Camp Lejeune, if you were stationed there and you have any type of disease, cancer, any type of health problem, feel free to give us a call. Also, if you are the child of someone who is stationed there, while they were pregnant with you and you have diseases or you have any kinds of problems, you may also have a claim. So feel free to give us a call. You could reach us at the phone number on our website. You can go also fill out one of our online forms, and myself or one of the attorneys at my firm will call you right back.